brief background, I am a constitutional lawyer. I've argued constitutional cases for most of the nearly 48 years I've been a lawyer. I've argued 2 in the Supreme Court. I've represented members of the Washington State Legislature in a constitutional challenge to the effort to extend the time for ratification of the Equal Rights Amendment back in the late 70s and early 80s. I'm one of the few lawyers in the country that's actually litigated an Article 5 case. I want to go to the last week of the Constitutional Convention very briefly to set some background. George Mason stood up on the floor of the Constitutional Convention and said, and I'm paraphrasing obviously, someday the federal government's going to abuse its authority. And when that happens, the method of proposing amendments where they can only come from Congress will never give us an amendment that will reduce federal power, because it's against nature for somebody to vote to reduce their own power. We've got to give the states the power to reduce the power of the federal government. And that change to the process, which is the current form of Article 5, was agreed to without debate. They saw the good sense of giving the states the ability to limit the power of the federal government. And so, as you've heard, 19 states have adopted this exactly, and under the belief that the federal government is in fact abusing its authority, and the twin belief that legislatures have the moral responsibility to exercise the authority that's given to them by the Constitution of the United States to stop this kind of an abuse of power. So if you believe that the federal government spends dangerous amounts of money and the escalating national debt is a threat to our future, you should support this resolution. If you believe the federal agencies shouldn't be able to make law without going through Congress, you should support this resolution. I would just note that we have 5 times as many federal administrative laws as we do laws passed by Congress. If you believe that we shouldn't be subjected to international law by the signature of the president only, and we should send all treaties to the Senate for ratification, where currently only 2 out of every 100 treaties is sent to the Senate for ratification. Those are the kinds of things that you can fix with this amendment, with this process rather. Now, the only questions that usually arise in a conservative state like Wyoming revolve around the claim the process will run away. And I want to deal with the first and most common argument in that regard that was brought up by the last speaker, and that is the myth that the 1787 Constitutional Convention in Philadelphia was a runaway. I've written what I consider to be, and many consider to be, the definitive article that's published in the Harvard Journal of Law and Public Policy that gives you the complete answer to this myth. The states called the convention. The directions to the delegates was to render the federal constitution adequate for the exigency of the Union. The argument that they were only supposed to amend the Articles of Confederation is a myth. And it came from a resolution passed by the Articles of Confederation Congress that simply gave their opinion as to what should be done at the convention. If you read the Articles of Confederation, there was no power in Congress to call such a convention. They didn't purport to call it, and nobody thought that they were. When the delegates looked at their authority, they looked at the resolutions coming from the states. I sent you all by email a few documents, including a 2-page summation of that Harvard Journal of Law and Public Policy article. But if you want the whole article, if you just Google my last name, Farris, which Farris, and then the words defying conventional wisdom, you can read the entire Harvard article online for free. There's no paywall. It's readily available to anyone. And I would just simply say, I think it's important for all of us to defend the integrity of the Constitution of the United States. Because if you say it was a runaway, what you're saying was illegally adopted. I just think that we should avoid ever saying the Constitution of the United States was illegally adopted. It denigrates our faith in the Constitution, and it's just historically not true. Secondly, I want to answer an argument that is commonly raised in many circles, especially conservative circles, that the convention could run away and would end up violating our rights. And I will use a common example in that we could lose our Second Amendment by this process. So I'm going to take that on head on. Now, there's a lot of reasons that wouldn't happen. It's not germane under the rules. It's not germane under the call. You can't change the rules in the middle of the stream. The ERA case that I litigated went to the Supreme Court, and and it's been litigated in recent years under efforts to try to revive the ERA, the holding of every court has been you can't change the rules in the middle of the stream. So let's just pretend that they still get away with changing the rules in the middle of the stream, despite all that precedent and despite all the impossibility of doing that. And just we're down to our last line of defense, and that is ratification. 38 states have to ratify any proposed amendment, no matter how it gets there. And if it's impossible, it's politically impossible to imagine a scenario where 38 states would ratify an amendment that curtails or eradicates Second Amendment rights. The number of states that have constitutional concealed carry provisions are well more than 13. I think it's about double that number. You can list off the states that would defeat such an amendment readily and get to around 30 really, really quickly that would defeat it. And it only takes one chamber in 13. So the political impossibility of that is simply so evident. I won't belabor the point, but I want to compare that to the status quo. Our Second Amendment rights were really only established clearly by the DC versus Heller case about 20 years ago. And that was by a 5-4 vote in the Supreme Court, because the contention was that it's only the militia that have the rights, which is basically the National Guard, and not an individual right. And the pro-Second Amendment forces won that by a 1-vote margin in the Supreme Court. So here's the scenario that can actually lead to the curtailment of our Second Amendment rights. You need an anti-Second Amendment president. You need a political party in control of both houses of Congress that's also anti-Second Amendment. In that scenario, the party in charge repeals the filibuster rule in the Senate, and then they move to expand the number of justices on the Supreme Court to whatever number they need to get a anti-Second Amendment majority in the court. And then they pack the court with enough anti-Second Amendment justices, and one of their state attorney generals brings a gun case to the court, and bingo, our Second Amendment rights are gone. That is incredibly realistic and is foreseeable, I would suggest, in the next 10 years. But the resolution that's in front of you can completely stop this, because the power to limit the power and jurisdiction of the federal government in this convention would include the ability to take away the power of Congress to set the number of Supreme Court justices. So an amendment that establishes that 9 is the permanent number of the Supreme Court is germane under this resolution in front of you. So the very best defense to stop the court packing, which is the greatest threat to the Second Amendment, is right in front of you. If you want to do something to protect the Second Amendment against the very greatest scenario that we could imagine, which is all too realistic, what you got in front of you would stop the eradication of the Second Amendment better than anything else. I would finally like to close. I've sent you also by email evidence that the John Birch Society, that I know has been active in Wyoming opposing us, that they came before this legislature, that same organization came before this legislature in 1959 and asked this legislature to pass a resolution calling for a convention of the states to pass the Liberty Amendment. I won't go into the details of the Liberty Amendment. I'll just say it's an amendment. I kind of like it. And Wyoming's legislature did call for a convention of states for that purpose. A number of states did at the time. I think it was in the 20s at the time. And now the John Birch Society tells us that doing this, it's too dangerous. Well, it's interesting. The John Birch Society has turned their back not only on the solution the founding fathers gave us, they turned their back on the solution that the founders of their own organization gave you. And I sent articles from the Sheridan, Wyoming newspapers in the early 1960s that show you that the John Birch Society was in fact behind the Liberty Amendment, and and I sent you the actual document of the Liberty Amendment itself, and this legislature's resolution calling for a convention of the states for that purpose. So.